Hi there. My name is Roger Hitchcock. I'm a senior associate with Sadar, and what I'd like to do is to take you through a new element or a new concept introduced in the new Companies Act in South Africa, Companies Act 71 of 2008. It's called the Business Judgment Rule, and really it flows out of directors' duties. So the Companies Act places, or for the first time, should I say, codifies directors' duties, and we'll touch on that in a bit. But alongside the codification of directors' duties, which increases the potential liability on directors, there is a defense, and this defense is called the business judgment rule. And essentially, what this defense wants to do is it wants to balance authority with accountability, and that's what the law essentially is looking to do. See, what the law does at, in a sense, quite a basic level, is any law creates a space. It defines that space. So on the roads, the space we have on a highway is a minimum speed limit of 50 kilometers an hour, 120 kilometers per hour maximum speed limit. And so that's the space. And whatever you do in that space is allowable. And that's the key thing about the law. If you stay within the parameters of the law, you have a defense. It's legal. But what the law wants to do as well is to find a person. And so that person is who the law wants to put accountability onto. And so the authority is given to act in the space, and the person is the one who is kept accountable or held accountable. And so that's those two key concepts go together. A critical thing about the law and about law that is effective is it gives authority and also ensures accountability. And that's what our Companies Act, the South African Companies Act, and most company legislation is really trying to do in internationally, is it's giving authority to the right people to run companies. And so that authority is given to the board. It's given to directors. In most legislations, the board is in a sense a secondary thing. Authority is given to the directors, and most company legislation, although it may require a single director, promotes a team of leadership. It gives authority to a team of people, directors, no distinction in most legal frameworks between executive or non-executive directors, but it gives authority to directors. But then because it's given authority, and all authority in terms of the company, to directors, it also holds them fully accountable for everything that happens in a company. And so with that in mind, what does a governance framework aim to do? Governance aims to manage or to mitigate or to balance three different, what I call I words. There's the concept of interest. Every individual comes to the table with their own set of interests. And when I say interest, this is the legal term. It's not just what are you interested in, but everybody, based on who they are and who they're related to and what they're related to, in other words, what other companies they're related to, has a set of interests. We talk often about the three hats, the different interests between shareholders, directors, and managers. Okay. At board level, the second I that governance wants to introduce is an independence of thinking, which is often brought into the room through bringing independent people into the room. That's the whole concept of independent non-executive directors, because it's all about decision making. And so decisions are best tested when we can step away from our personal interests and understand our interests. What is the key interest we have to have as directors? And so the third thing about governance is it wants to ensure that we take into account the impact of our decisions. And so that's the context for the business judgment rule. Going back to the legal duties of directors. So directors are required by law, as we said before, to act with due care, skill, and diligence. They have a fiduciary duty, which basically means good faith. Fiduciary means the same level of care that a father would have towards their children. So out of that, they need to act in good faith. They do need to act in the best interests of the company, and so that word interests comes in. There's a legal duty for directors to put their own interests aside, or to make their own interests secondary or tertiary, and to ensure that they act in the best interests of the company. And so that means that they need to avoid conflicts of interest. And so governance focuses quite a lot on this concept of conflict of interest, because the assumption is that if there's a conflict of interest, we will tend towards acting in our own interests and not in the interests of another party. And that other party is the company that we as directors are responsible for and responsible, accountable to. There's a fiduciary duty not to use their position for personal gain. This is obviously directors are paid, and there is the contractual arrangements, but because directors are exposed to information and potential information and numbers and structures they can manipulate, often directors in the past have done that for their own personal gain, and directors must exercise the powers for the purpose for which they were granted. And that's why the distinction between shareholders, directors, and managers is important, because directorship has a very specific purpose, and that is to act in the best interests of the company. And so the business judgment test comes in after the legal duties of directors. So legal duties of directors are put into the legislation. This is how directors are expected to act. The business judgment test comes in and says, well, we've now got to balance the authority that has been given and the imperative to act. So directors must act. They can not sit and do nothing. They can't just tick the boxes. Directors have to act, but they also need to be held accountable. And there's obviously the liability that is also created in the legislation. And so the business judgment test, or the business judgment rule, is a defense that directors can use that essentially wants to firstly promote risk taking. So running a business is a risk taking exercise. It's an exercise in risk taking, because that's what decision making is all about. So it is a defense that directors can call on. It does want to encourage competent directors to serve. So competent people to serve as directors. So the business judgment test, you'll see what the components are next, but it encourages people who are willing to act independently, willing to investigate, willing to self-develop. Thirdly, it wants to prevent what's called judicial second guessing. What that means is when the law tests a decision, so normally if something goes wrong, it ends up in court. The law doesn't want to have to look at whether the decision you made was actually a good or a bad decision. The law is not interested so much in the net result of your decision, but the law is interested, and you'll see the business judgment test enables the law to focus on how you made the decision, the process of making the decision. Because the reasonable person test in law says that if a reasonable person or a reasonable group of people would have given a robust process of decision making, made a similar or the same decision as you, then there is potentially a defense. It also aims to avoid the stakeholder manager trap, so the conflict of interest, the conflict of selfish interest of a shareholder versus selfless interest of a director, and also wants to allow room for more efficient market mechanisms. What that means is that directors should be continually judging themselves and evaluating their own performance, as opposed to just relying on a legal defense that they can call on when necessary. So what does the business judgment rule comprise of? Well, there are 4 key elements. And I'll unpack these, but briefly, a decision or judgment must be made. So that's the context. Decisions must be informed. Conflict of interest must be managed or mitigated, and there must be a rational basis for the decision. The decision must be in good faith. And what each of those mean in brief is that firstly, there must be a conscious decision. The context for the business judgment test is the word judgment, or the business judgment rule is the word judgment. A decision to do or not to do. So there must be a conscious decision. Now, important, the distinction, some people say, well, we didn't do anything, but consciously not doing something is also a decision. So simply failure to act doesn't draw on this defense. So if the counter argument is, well, you simply failed to act, you were negligent, the law isn't going to support you then. Neither does rubber stamping, which says, oh, well, we had to do it. Because the business judgment rule is not interested. It's interested in saying, did you evaluate the various risks and impacts? So the second thing about this, did you look at the consequences related to the decision? Did you have a process for identifying, analyzing, evaluating the impacts and consequences and risks related to the decision, as well as the underlying assumptions? All right, have you tested those assumptions, as well as tested the impact, tested the potential, the decision you made was obviously aimed to avoid certain things or embrace certain things. So all of those things need to be tested, and that needs to be shown in a decision-making process. That's what the business judgment rule is looking for. Secondly, decisions must be informed. In the South African Companies Act, there's a definition of knowingly knows, and know, which essentially means that directors are in a position in which they ought to have known, and so are given the gap to investigate and do something that enables them to know. The law assumes that if you're a director, you know what you're doing. And so the defense could be the fact that you've actually put together a consistently applied methodology, that you've asked all the right questions, you've asked questions a reasonable person would want to answer, you've examined assumptions, all of those things. And ultimately, it's the process used to come to the decision and not the merits of the decision, which would be under investigation. Hence the term earlier, to avoid judicial second guessing. If the law has a process to look at and the process makes sense, it doesn't really have to look at the merits, because the defense is in the process and not the merits ultimately. There must be an absence of conflict of interest, a declaration of any conflict of interest, and the law requires a recusal, leaving the room. Important to minute that. Important in the process to ask a definitive question, a yes/no question, as opposed to a well, I don't know, or one that leaves any gray area. So that's fairly clear. The law requires declaration of conflict of interest. And then ultimately it does boil down to this concept of good faith. And the fiduciary duty to act in good faith assumes that there's a rational business purpose, all right? And assumes that that business purpose is obviously legal and substantial and robust. Good faith also comprises integrity and honesty. And so that integrity and honesty to some extent speaks to the independence of mind. Have the group of directors independently examine the issue, even if they are someone who would be conflicted, a shareholder manager, and sitting with some of those challenges. And so ultimately, every decision will be tested as long as you know what you're doing and can show that you investigated it, as long as you've got conflict of interest declared and recusal, I mean, the right people were in the room. Ultimately, it boils down to this discussion or decision around what the best interests of the company are all about. And in today's world, the word sustainability, those kind of concepts about surviving and thriving as a business are becoming more and more debated. And so in a nutshell, what the law does and how it's phrased in the law is the three key steps. Can we show the taking of reasonably diligent steps to become informed about the matter? Hurdle number one, if we can jump over that, we can go to the second hurdle, no material interest, in other words, no conflict of interest in the subject matter of the decision that the person or the people or related people would have, or a declaration. So the defense there is there's either none, or if it is, we've declared it and recused ourselves. That's hurdle number two. Hurdle number three, we have a rational basis for believing that the decision was in the best interest of the company. And that's really the crux around which all of this turns. And this is, in a sense, a three-hurdle race. You've got to jump over all three hurdles to be able to call on the defense of the business judgment test or the business judgment rule. You trip up on any of the three and you lose your defense as directors. And so you can see that it's the law places significant liability on decision makers, but also gives a fairly elegant defense if it's properly applied and systematized. And ultimately, we've got to understand that any business, no matter what it is, large or small, for profit, not for profit, public sector, private sector, but at its most basic level, running any business or organization is really all about making and implementing decisions. And that's what the focus of the South African Companies Act and most corporate legislation aims to look at. It says, how do we make sure that the parties that make decisions understand that they need to act in a certain way, care, skill, and diligence, fiduciary duty, as well as the fact that they need to put processes in place that ensure that they know what they're doing, they're informed, they've investigated, they've discussed and debated the right things. We've asked the question around conflict of interest because that's a critical issue. So the independent thinking, the conflict of interest that is managed, we think about the impact of our decision on those we the stakeholders, but also more importantly, or most importantly, the business. What is the primary responsibility we have as directors is to act in the best interest of the company. And so it's the company's interests that must benefit, and we need to be able to express that and show how we've actually ensured that in applying the business judgment rule. And so ultimately, the business judgment rule is a defense. Directors can call on it if and when things go wrong, but they can also and should also embed it into the way they make decisions and the way they operate on an ongoing basis at their level and at other levels.